Part 1, Section 1. Let's start with Part 1, Section 1, and examine the role of a guardian ad litem in Wyoming. We'll consider your role in the proceeding. Specifically, we'll examine the hybrid model and best interest approach. You'll learn more about maintaining proper role boundaries and being a zealous advocate for your client. Finally, in Section 1, we'll discuss collaboration with the CASA and DFS caseworker if you're working with either or both. Acting as a guardian ad litem, GAL, is an extremely difficult yet rewarding job. The most fundamental aspect of this vocation is an understanding of the role you play in the system and for your clients. It requires a high level of competency in many areas, the ability to communicate and connect with children of all ages, capabilities, and backgrounds, as well as a specialized skill set to navigate a primarily non-adversarial juvenile court system with the same zealousness and trial advocacy an attorney would use in adversarial court systems. In the United States, there are 4 types of child representation in juvenile court proceedings. First, there is an attorney to represent the child in the standard attorney-client relationship, where the lawyer relies upon the diminished capacity rules of professional conduct if the child is nonverbal or diminished in any way. This is a direct attorney role. Second, there is a pure best interest role, where the attorney presents and advocates solely for what the attorney believes is in the child's best interest. The attorney owes no allegiance to what the child wishes, informing what the attorney believes to be in the child's best interest. However, the child's wishes are often taken into consideration. Third, there can be 2 attorneys for each child, 1 direct attorney and 1 best interest attorney. Finally, there is a hybrid model, in which 1 attorney performs both of these functions at one time. In Wyoming, it is your duty to represent clients in the hybrid role in cases of abuse and/or neglect, termination of parental rights, and appellate proceedings. This means that you must represent the child's wishes and the child's best interests at the same time. Often, if you counsel the child appropriately and effectively, the child's wishes and the child's best interests will align. Wyoming Statute 14-3-211 Section A, referenced in the handbook, sets forth this right of the child to representation by a hybrid model GAL. The statute states, "The court shall appoint counsel to represent any child in a court proceeding in which the child is alleged to be abused or neglected. Any attorney representing a child under this section shall also serve as the child's guardian ad litem unless the court has appointed a guardian ad litem. The attorney or guardian ad litem shall be charged with representation of the child's best interest." In Wyoming, the hybrid role was adopted by the Wyoming Supreme Court in 1998 in the Clark v. Alexander case. It was reaffirmed 3 years later in Pace v. Pace, which also restated that the hybrid GAL is an attorney and not a fact witness. In child in need of supervision, referred to as CHINS, and delinquency proceedings, your role as a GAL in Wyoming changes to that of a pure best interest attorney. This is because a child in these 2 types of proceedings has a right to an attorney who provides direct representation through the Office of the Public Defender. Wyoming Statutes 14-6-222 Section A and 14-6-422 Section A, referenced in the handbook, set forth the right to counsel for all children in CHINS and delinquency proceedings. Rule 5A of the Wyoming Rules of Procedure for Juvenile Courts also states, "The respondent is entitled to be represented in all proceedings in juvenile court by counsel retained by him, his parent, or by counsel appointed pursuant to this rule." Thus, in certain circumstances, the child may have 2 attorneys, 1 direct attorney and 1 best interest GAL. However, in other cases, just a direct attorney may be appointed. Appointment of a GAL is optional. Wyoming Statutes 14-6-216 and 14-6-416, referenced in the handbook, state, The court shall appoint a guardian ad litem for a child who is a party to the proceedings under this Act if the child has no parent, guardian, or custodian appearing in his behalf, or if the interests of the parents, guardian, or custodian are adverse to the best interest of the child. As a GAL in CHINS and delinquency proceedings, you should ensure that the child understands the right to a direct attorney and is appointed or hires a direct attorney if the child so desires. Representation and protection of the child's rights is essential. In both CHINS and delinquency proceedings, if the child qualifies financially, a public defender can be appointed to represent the child pursuant to Wyoming Statute 7-6-112, Section A1. Let's look further at the hybrid model of representation. The model is defined in the Wyoming GAL Program Rules and Regulations in Section 2A. The hybrid model provides an attorney to represent the child's best interest, but rather than taking direction from the client, the attorney guardian ad litem uses his or her own judgment about the child's best interest. You still consider the child's wishes, but you are not bound by them. If your judgment and the child's preferences disagree, you must present both sides to the court. As counselor and advisor to the child, you should do your best to help the child understand his or her legal rights and obligations, and explain what those rights and obligations mean for the child. Explain all aspects of the case and make sure you counsel and advise on different case options. You should also make sure the child understands that you will address concerns about his or her safety, health, and welfare. In the case of a child that is unable to communicate, base your determination of the child's legal interest on the laws related to the purposes of the proceedings, the child's specific needs along with your objective best interest determination, the goal of speedy resolution of the case so the child can remain or return home or be placed in a safe, nurturing, and permanent environment, the use of the least restrictive alternatives available and appropriate for the child. Proper role boundaries. It's critically important that you understand and abide by the role boundaries in the GAL and client relationship because your clients are minors. Your maintenance of the boundaries will help ensure the child's protection as well as your own. The requirements are articulated in the GAL Program Rules and Regulations, specifically the policy on client meetings and relationships. We'll talk more about the requirements for meetings, locations, and timing in a later module. For now, let's take a look at potential boundary issues. Your role in juvenile court can often be blurred due to the nature of the cases and the families involved. Part of your job is to engage the client in a relationship of trust. Yet, when working with these child clients, you must maintain clear boundaries to assure professional integrity and responsibility. Your role is not to parent or save the child, but to advocate for the child's needs and best interests in the legal proceeding. To resolve this legal problem in a productive and effective manner, you need to develop a healthy adult relationship with the client while maintaining an objective detachment from the client. Maybe it will help you define your role when you consider what is prohibited by the GAL program. While you can see the full list in the handbook or the program rules and regulations, some that help to make the point include sexual relations with the client or a member of the client's family, initiating gratuitous talk about sex, physical contact with sexual intent, rough handling, lending money to a client, receiving money or services from the client for yourself, accepting as a client someone whom you have had a business relationship, accepting as a client someone who is or was a member of your family, accepting as a client someone you have known socially, giving the client a personal mobile or home phone number, a personal email address, or a home address, spending time with the client at your home or at various restaurants, movie theaters, or other social facilities outside of the client's home or placement, where the purpose of the meeting is purely social and not related to the client's juvenile court action. Freely sharing and discussing your own personal experiences or intimate details about yourself with the client, and engaging in the use of drugs and/or alcohol with the client. Neutrality v. zealous advocate. Because of your professional requirements and the age of your clients, attorney GALs often struggle with balancing between the neutrality required to determine the child's best interest and the passion and drive required to represent the child during the proceedings. Just remember that your client must have an advocate in court. Once you have determined your client's best interest, pursue it with zeal. Roles and duties. By now you understand how important it is that you remember at all times that you are the child client's legal representative and not the social worker or any other kind of advocate. Your role is to lead the child through the legal system in all the court proceedings. While you work with the child client, you may become aware of their need for other services. Some of the partners that you may work with during the process may be helpful. Let's take a minute to look at some of the people and organizations you might interact with during your cases. The court-appointed special advocate, referred to as a CASA, can be a very helpful assistant for the child. However, CASA organizations are available only in some communities in Wyoming. In addition, a CASA's role is limited to abuse and neglect cases, and each CASA organization has defined for itself which abuse and neglect cases it accepts, as well as how its program operates and collaborates with the juvenile court system. The handbook on page 19 provides more detail about what a CASA volunteer may do for your child client, and it points you to additional information about the CASA program, including a list of communities in Wyoming where CASA is available. Be aware that when they are available, a CASA volunteer can be a key asset to you because they can testify regarding what they witness while you cannot. Juvenile court rules strongly encourage GALs and CASA to collaborate on cases. The Department of Family Services, DFS, provides a caseworker. The caseworker's role is devoted to the family unit in addition to the child. While working closely with the caseworker will benefit you as a GAL, be careful that you don't perform their duties. Wyoming statutes require the juvenile court to appoint a multidisciplinary team, or MDT, in all child abuse and neglect cases, as well as in child in need of supervision, or CHINS cases, and also in delinquency cases. The appointment of the MDT must occur within 10 days of the filing of a petition. The MDT operates in compliance with Wyoming statutes 14-3-427 Section E, 14-6-427 Section E, and 14-6-227 Section F. They review the child's personal and family history, school records, health records, any DFS records, and all other pertinent information related to the child. Following careful review and discussion, the MDT makes recommendations to the juvenile court in child abuse and neglect, CHINS, and delinquency cases. In delinquency cases, the MDT recommendation should be consistent with the purposes of the Wyoming Juvenile Justice Act. The Act promotes a balanced and redemptive approach that addresses victim reparation, accountability, and competency development. The MDT considers the best interests of the child and the best interests of the family. They look for the most appropriate and least restrictive case planning options and consider the costs associated with caring for the child. An MDT is intended to ensure that all the circumstances impacting the child and family are fully identified and considered in making recommendations to the court. This means they will consider the strengths of the family and identify the services and supports that will help meet any needs of the family. The MDT should also recommend measurable goals designed to track progress in addressing a family's pertinent issues. As a GAL, you should always attend MDT meetings on behalf of your client. You should also advocate for your client to be a member of the MDT and attend meetings. With this many people involved in making decisions for the child and family, disagreements are bound to arise. Of course, disagreement can be healthy when it causes everyone involved to continue the search for the best solutions. Remember to handle disagreements in a professional manner. Watch your demeanor in meetings, on the telephone, and even by email. Do your best to give others involved in the process a heads up before you deliver new information in court or at an MDT meeting. And of course, remember that as a legal advocate for your client, you should not necessarily share everything that you know. Now let's look at Section 2. Let's talk briefly about the history of the GAL program in Wyoming. The Wyoming legislature created a GAL program in 2005. Prior to that time, each county was responsible for interviewing, hiring, reimbursing, and supervising any attorney GAL practicing in their county's juvenile court. This duty was left to many different individuals and varied from county to county. Lack of standardization impacted the quality of representation offered to children throughout the state. In addition, an attorney GAL rate of pay also varied depending on location, as did the amount and quality of training available to GALs. To eliminate these inconsistencies, the legislature created a GAL program and appropriated $4.2 million each biennium. Responsibility for the program first resided with the Wyoming Supreme Court, Wyoming's judicial branch. The Supreme Court maintained a list of qualified GALs in each Wyoming county. The county then chose from this list for a GAL in each juvenile court action, and the county was reimbursed for the GAL's time. At that time, no attorney GAL could carry a caseload of more than 65 cases. While the Supreme Court administered the program, a number of improvements were made, including the creation of standards, establishment of caseload maximums, standardization of pay at $100 per hour, and increased training. And yet some issues lingered with regard to how counties applied the standards and paid their attorney GALs, leaving the Supreme Court in a position of appearing to supervise attorneys that appear before the court in cases. Therefore, the Wyoming legislature moved the GAL program to the Office of the Public Defender beginning July 1, 2008. The OPD hired an attorney to administer and oversee the program. This allowed the program to establish supervision and provide robust case resources and assistance. Beginning July 1, 2008, all GALs who represent children in juvenile court have to contract with the OPD instead of the counties in which they practice. GALs are paid directly from the GAL program, and the program bills the counties for 25% of this cost. This allows a greater connection between the state dollars and the legal representation. Other major changes included changing the caseload standards, increasing the specificity of the representation standards in the rules, and taking over the case appointment process to ensure that qualified and appropriate attorneys are assigned, caseloads are suitable, and that attorneys are appointed in a timely manner. The current GAL program rules and regulations were adopted in December 2008 and updated in 2013. They contain detailed guidelines regarding your duties and responsibilities. You should read these rules and be very familiar with the requirements. They are found on the GAL website at gal.wyo.gov. In addition to these rules, there are GAL program policies you must know and follow. We'll highlight some key policies for you now. The policy on conflict of interest governs your ethical conflicts. It defines and discusses access of files, case conflicts, concurrent conflicts, business transactions with clients, conflicts with past clients, conflicts between clients, and firm association conflicts. It also gives direction on how to handle a conflict and a form to request the appointment of a new GAL due to a conflict of interest. The policy on formal complaints is posted on the program website and given to anyone who calls the program with a complaint regarding your representation of a client. The program reviews and investigates all formal complaints submitted against you. No formal complaint is accepted anonymously, and all formal complaints must be in writing. You will have an opportunity to respond to all complaints investigated by the program. Upon receipt of an appropriate complaint, the administrator reviews the complaint and initiates an investigation. In the review, the administrator studies the complaint and your actions to ensure compliance with the program rules, regulations, and policies. The administrator does not review individual decisions or recommendations made by you in specific cases, nor orders of placement or custody of a child. The most common formal complaint is that you have not met with the client or observed the client in their home. Per Wyoming law, all children in CHINS and delinquency proceedings must attend court hearings and therefore should attend the MDTs as well. The Children in the Court policy takes this a step further and states that all children, regardless of age or type of juvenile court case, should attend all significant court hearings in which they are the subject. Even those clients that are not old enough to understand or participate in the proceedings can and should attend. Such attendance may benefit the parties and team members. The GAL program adopted the Policy on Client Meetings to guide the frequency and timing of meetings with your clients, as well as your professional relationships with clients. The policy contains many specific instructions, including the list you see on your screen. A GAL is required to maintain sufficient contact with the client to establish and maintain an attorney-client relationship, meet with the client in person as soon as you have been assigned, but in no case longer than 30 days from appointment to the case. Meet with the client at his or her home or current placement within 30 days of any change in placement. Meet with the client in the child's home or current placement whenever possible so the GAL can observe interactions with the caregivers. Meet again with the child in person and not at the courthouse right before a hearing or MDT when there is a change to a child's activities, such as changes in placement, school suspensions, inpatient hospitalizations, major court hearings, etc. Ensure meetings take into account the child's age and maturity, and you shall inform the client about the case. Meet with all clients in a case. Balance the cost and needs of the client when traveling out of state to meet with the client. Avoid conflicts of interest or potential conflicts of interest. Maintain professional boundaries with the child clients, and know which behaviors are prohibited and which may signal violations of the professional relationship. Of course, you can find all the policies in the Wyoming GAL program rules and regulations at the website, and if you have any questions or concerns, the program administrator is there to help you. Contact information is available on the website and on page 24 of the GAL handbook. The main office number is 307-777-7480.